Security and confidentiality are not issues only with regard to electronic data. Paper records and even casual conversations are covered under both FERPA and HIPAA laws and regulations. Sometimes breaches of data security and confidentiality occur in mundane and even non-digital ways. Leaving a window of student information visible on a computer screen when going to answer the question of a parent in the office. Leaving a folder of student information unattended on a desk. Discussing a student or staff discipline issue in a public area where it is overheard. These behaviors, although natural and quite common, are bad practices. They can result in the violation of the right to privacy of a student or staff member and further result in lawsuits and expenditures of district funds. The purpose of FERPA is to protect the privacy of student education records and define clearly what rights students and their families have to access those records. One way it protects privacy is by requiring consent before personally identifiable information is disclosed. Such consent must be obtained from the parent or from any student 18 years or older, or enrolled in a post-secondary institution. There are some exceptions to this general consent rule, the most common of which is the exception for directory information. Any information about a student that might be included in the LEA's publicly available student directory does not require explicit consent to disclose. Such information could include first and last name, grade level, phone number, parents' names, etc. Parents do have the right to ask that even directory information be kept confidential, but they must make that request explicitly. FERPA also requires LEAs to notify parents and eligible students annually about their rights under the law and under FERPA regulations. The model notification posted on the U.S. Department of Education's website is quite extensive. It covers the right to consent to disclosure of personally identifiable information, the right to inspect, review, and amend a student's educational record, and the right to appeal to the U.S. Department of Education. Keep in mind that FERPA is not the only law that governs the confidentiality of student records. Many state laws and regulations are on the books, and they are at times more stringent than the federal rules. A web-based or print guide to the legal environment of your LEA's state is an essential reference for administrators and other LEA staff. Although directory information may vary from LEA to LEA and from state to state, some data elements are invariably considered confidential. These elements require consent from parents or eligible students before they can be disclosed to another individual or agency. And although it is easy sometimes to forget, staff information is also subject to confidentiality laws and regulations of various types, including HIPAA. The information listed here, Social Security number, health and medical information, contract information, should not be disclosed without the express permission of the employee involved. There is a broad exemption in HIPAA's privacy rule that excludes health information contained in education records as defined in FERPA. Health information that is maintained by an LEA is subject to FERPA access and disclosure rules, no matter who creates and uses the information. However, the interaction of FERPA and HIPAA as they apply to schools is somewhat complex. Sometimes HIPAA rules regarding the sharing of medical information may apply to a school, yet at the same time so do the FERPA rules on consent for disclosure. Some HIPAA regulations might also apply to an LEA that provides healthcare services, such as clinics, to students. An LEA must do its best to be sure its nurses and administrators understand the many and complex implications of these regulations to ensure that this private student information is kept confidential and secure. There are several basic practices to reinforce an LEA's commitment to keeping data secure and confidential. Establishing, documenting, distributing, and providing training on procedures and protocols governing the release of information is essential. These procedures would include providing student information to colleges, other LEAs, local service or recreation agencies or programs, etc. LEAs should also prepare plans for dealing with a data breach. Confidential information, as the news often reminds us, can be made public through theft, computer hacking, or plain carelessness. Establishing and implementing procedures for quickly notifying those whose data has been leaked and preventing further breaches will go a long way to mitigating any liability an LEA might incur. Finally, LEAs must be careful to avoid making public data or reports that can identify students even inadvertently, because the identification is implicit in the report. For example, a report showing that 100% of students in School A are on free or reduced lunch reveals confidential information about each individual student. Including the achievement level on a statewide assessment of the white students in School B reveals confidential information if there is only one white student in School B. This kind of data breach can be easy to stumble into, especially if an LEA has low enrollment. Avoiding this type of breach requires both being familiar with the school population and being thoughtful before issuing reports to the public.